Hi, I'm Ken Fossen. Today, let's examine this hypothetical fact situation. School District number 13 has a 6-member board, but one of the members moved out of state, so there's a vacancy on the board that needs to be filled by the remaining 5 members. Action to fill the vacancy is scheduled to be taken at the board's regular meeting on Monday evening. On the Friday night prior to the board meeting, all of the remaining members were at the high school attending a basketball game, when the following conversation between the president and the treasurer of the board took place. President: I've heard some rumors about one of the people we're considering to fill the board vacancy, and I think we should get our ducks in a row before Monday night. Why don't you get the other members and I'll get the superintendent and we can discuss this matter in his office at halftime. Treasurer: We can't do that, can we? President: Hey, what can they do? Reduce our salary? Treasurer, laughing: You've got a point. I'll get the others. See you at halftime. Let's first review some of the statutory provisions the board may have violated. Then we'll proceed to review the remedies available to the public and the consequences that may be in store for the school district and the individual board members. Section 84-1408 states, "It is hereby declared to be the policy of this state that the formation of public policy is public business and may not be conducted in secret." Well, the board clearly violated that policy statement, but let's continue on to the specifics. Section 84-1408 goes on to state, "Every meeting of the public body shall be open to the public except as otherwise provided by the Constitution of Nebraska, federal statutes, and the Open Meetings Act." This section presents us with 2 questions. First, what exactly constitutes a meeting? And second, is there an exception that might cover this situation? On more than one occasion during my career, I've heard board members say that their activity was not really a meeting, but rather it was an informal get-together to visit. With that in mind, let's look at section 84-1409-2, which provides us with the definition for the word meeting. For purposes of the Open Meetings Act, unless the context otherwise requires, meeting means all regular, special, or called meetings, formal or informal, of any public body for the purpose of briefing, discussion of public business, formation of tentative policy, or the taking of any action of the public body. Well, it looks like the board president in our hypothetical called an informal meeting of the board to discuss the issue of selecting a person to fill a vacant position on a public body. So this get-together appears to clearly fall within the statutory definition of a meeting. Now, the only hope for the board is to find an exception for this type meeting. As you might expect, there's no such exception. In fact, as you may recall from a previous presentation, there is a statute that specifically states the opposite. Section 84-1410 provides that nothing in this section shall permit a closed meeting for discussion of the appointment or election of a new member to any public body. So even if the board members had waited until their Monday meeting and then went into closed session to get their ducks in a row, they would still have been in violation of the Open Meetings Act. Okay, it's pretty clear that the board violated the Open Meetings Act with their halftime meeting with the superintendent, but so what? Well, let's look at section 84-1414-3, which provides that any citizen of this state may commence a suit in the district court for the purpose of requiring compliance with or preventing violations of the Open Meetings Act, for the purpose of declaring an action of a public body void, or for the purpose of determining the applicability of the act to discussions or decisions of the public body. Section 84-1414-1 further provides that any motion, resolution, rule, regulation, ordinance, or formal action of a public body made or taken in violation of the Open Meetings Act shall be declared void by the district court if the suit is commenced within 120 days of the meeting, and shall be voidable by the district court if the suit is commenced more than 120 days, but within 1 year of the meeting. So, for example, if the board at its halftime meeting on Friday got his ducks in a row and decided to appoint John Doe to fill the vacancy at their regular meeting on Monday, the plaintiffs in the lawsuit could use Section 84-1414 to request the court to automatically void such appointment if they filed their suit within 120 days, or ask the court, in its discretion, to void the appointment if the suit was filed after the 120 days, but within 1 year. In addition to voiding the action of the board, Section 84-1414-3 also provides that the court may order payment of reasonable attorney fees and court costs to a successful plaintiff in a suit brought under this section. And that's not the end of the story. The board members may also find themselves being charged with a criminal violation for their actions. Section 84-1414-4 provides that any member of a public body who knowingly violates or conspires to violate, or who attends and remains at a meeting knowing the public body is in violation of any provision of the Open Meetings Act, shall be guilty of a Class 4 misdemeanor for the first offense and a Class 3 misdemeanor for a second or subsequent offense. Section 28-106 provides that for a Class 4 misdemeanor, that's the one at the bottom, the maximum sentence is no imprisonment and a $500 fine. And for a Class 3 misdemeanor, the maximum sentence is 3 months in prison or a $500 fine, or both. I hope this was beneficial. Thanks to the attorneys at Perry Law Firm for their assistance in planning, research, and writing for this presentation. And of course, thank you for watching, and we'll see you again next week.